Oh, really? What's that?
Okay.
Yeah, it was. So we'll send it last night.
See, you have it, Mom.
Yeah.
Go ahead and stay.
Did you turn yours off?
Good afternoon,
Afternoon.
and you may be seated. All right, let the record show. We're on. Yeah. Today's date is October the 4th, 2023. We are in the Pike County Court of Common Pleas, the General Division, the Criminal Division. We are here on State of Ohio versus George Washington Wagner III, case number 2018 CR 000157. This is Judge R. Allen Corbin acting by assignment from the Supreme Court. And we are here this afternoon for a hearing and oral arguments essentially on the motion for change of venue. The defendant through counsel filed a motion for change of venue back June 15th. Another copy was on June 20th, but then there was an amended motion for change of venue by the defendant on June 22nd, 23. The state filed a memorandum contra the defendant's motion for change of venue on August 30th, and then the defendant has filed a response to the state's memorandum contra regarding change of venue. That was filed August 3rd, yesterday, I guess, of this year. And present here this afternoon on behalf of the state of Ohio is Angela R. Canepa, Special Prosecutor, and I'm sorry, once again.
It's Special Agent Scheider, Your Honor.
All right.
Special Agent Scheider.
I apologize,
It's
sorry,
okay.
sir. All right. The defendant, Mr. Wagner, is present with his counsel, and Mr. Wagner is in civilian clothing. Mark C. Collins and Caitlin Stevens are both here, as are Thomas F. Hayes and Emily Anstedt. And we will be having oral arguments, as I said, and in all probability, I will not issue my decision from the bench here this afternoon, even if I have an idea as to which way I intend to go. I would prefer, and I've discussed this with counsel, and I believe they're all right with it, but I'd prefer to do a written decision setting forth my rationale and reasoning for whatever decision I make. And I do believe that I will be able to get that out in a fairly timely fashion. As I said to counsel, I don't have a lot of other stuff that's extremely pressing, and I will give this number one priority. Is there anything else from the state,
No, Your Honor.
from the defense?
I think the only other thing, Your Honor, is that we potentially, we have agreed upon, I think, in general conceptual terms of a trial date of May the 6th.
All right. We did come up with a trial date in this matter. Excuse me. May the 6th of 2024 is the date that has been selected, and we've gotten, I think, approval from all counsel and the court. Right now, it is scheduled, at least tentatively, for 8 weeks. We don't know if we'll need all that or not. We'll see how things develop. And then between now and then, I would anticipate there may be at least a couple more hearings on pretrial issues that we may need to address. And some of those I will make decisions from the bench. But on this particular motion, I would prefer to set forth my rationale. And just for the record, I have read all the documents which have been filed in regard to the defendant's motion for change of venue, the state's response contra, and the defendant's response to the state. And there are cases that have been cited, 4 or 5 in particular, and I have read those cases. I pulled those up and read those cases. So I am familiar with everything that you set forth in your memoranda, counsel. And with that, Ms. Stevens, it's my understanding you will be arguing on behalf of Mr. Wagner, is that correct?
That's correct, Your Honor.
All right, you may proceed when you're ready.
Thank you very much, Your Honor.
You're welcome.
May it please the court. Your Honor, we're here today asking that you grant our motion for a change of venue on the basis of the presumed prejudice doctrine that was set forth by the Supreme Court of the United States in United States v. Skilling. Your Honor, the Supreme Court has held that there are cases in limited circumstances wherein presumed prejudice exists, such that any attempt to seat a jury would be done so in vain. This, Your Honor, is what we have here with Mr. Wagner's case, a rare, limited case, a case of first impression here in the state of Ohio, Your Honor. This is the kind of case that the Supreme Court contemplated when it gave us the doctrine of presumed prejudice in United States v. Skilling. This is, Your Honor, so far in Ohio's history, the largest murder investigation that this state has seen. It is one of the most expensive, such that if the citizens of this county had to foot the bill for these trials and these trials alone, this county would potentially go bankrupt, Your Honor. It is one of the longest murder cases that the state has seen. It is a case wherein all co-defendants were indicted with death specifications, so we have to death qualify jurors, only for the state of Ohio to subsequently dismiss the death specs during trial, should Angela and Jake Wagner cooperate. This case is happening, Your Honor, in a county that has already heard and already decided a co-defendant's case. None of the cases, Your Honor, that the state of Ohio cites in its memorandum contra have that kind of title-wielding power, and none of those same attributes. As such, Your Honor, this case is in fact distinguishable. This is the rare, limited case that the Supreme Court of the United States contemplated when it decided that presumed prejudice certainly can exist and gave us a factor test, Your Honor, to examine whether or not presumed prejudice does exist. And so these factors must be analyzed, Your Honor. And here we have 3 of the 4 delineated factors in United States v. Skilling to examine in that favor change of venue and state that presumed prejudice exists here. The first factor that the court must analyze, Your Honor, is whether pretrial publicity contains blatantly prejudicial information, the type of information that viewers cannot be reasonably expected to shut from sight. In its memorandum contra, Your Honor, the state focuses on quantity of pretrial publicity. But the court mustn't forget, Your Honor, that it needs to look at the quality of the pretrial publicity. Not just how much is out there, but exactly what the content of that pretrial publicity is. And the content of what is said, what has been said, and what is currently in the pretrial publicity is in fact blatantly prejudicial. Here, Your Honor, we have government officials, Sheriff Al Lewis, warning Pike County local residents that we've got one more to go, and we're going to get that one too, referring to our client, Your Honor. We have members, Your Honor, of the prosecution team in spite of the gag order that exists on this case, calling our client, A. Wagner, an evil monster, telling members of the community, advertising that the Wagners, including my client, is an evil monster, while the prosecution still has this case to try. Pretrial publicity, Your Honor, has not only been pervasive, it is not only adverse, as the state wants to claim, but it has crossed the threshold into now being prejudicial. It has contained blatantly prejudicial information that no reasonable viewer can be expected to shut from sight. The blatantly prejudicial information, Your Honor, that the government has said to the media would never be allowed to be introduced in front of a jury here in Mr. Wagner's case. This court would never allow the sheriff to come and take the stand and say what he said to the media. This court would never allow the prosecution team to refer to my client in front of a jury as an evil monster. This court would preclude that very information from being told to a jury as prejudicial character evidence. And so the pretrial publicity here, Your Honor, is not only pervasive, it is adverse, and it certainly has crossed that threshold of becoming prejudicial. As such, Your Honor, this factor favors the change of venue and indicates that prejudice here should be found as presumed. The second factor, Your Honor, that the court must examine under the presumed prejudice doctrine is the size of the community. We have provided the court with a count of registered voters granted from the year 2020 in Pike County. There are roughly 17,000 registered voters in this county. By way of analogy, Your Honor, the Columbus Crew Soccer Stadium holds more seats than our registered voters here in Pike County. This county is small, Your Honor, and again, has already heard one trial. It has already decided one trial. The state wants to be able to argue that they were able to seat a jury with trial number one, and so number two will easily be accomplished. But the numbers, Your Honor, and the statistics that we cited in our motion tell a different story. Out of the 1,000 summons that this county sent out, only 300 people appeared pursuant to summons. There's no doubt, Your Honor, that Pike County is small in terms of population and tight-knit in terms of community. The numbers and statistics from trial one are included in our motion, and they do in fact favor a change of venue and a finding of presumed prejudice. The third factor, Your Honor, that the Supreme Court gives us to examine is whether media coverage has lessened with the passage of time. Your Honor, half of your courtroom here today is media. The media room downstairs is full. Trial one, Your Honor, was streamed every day. There is no such thing as lessened media coverage with Ohio's largest murder case and murder investigation. Again, Your Honor, as such, this factor favors a change of venue and favors a finding of presumed prejudice. Now, the prosecution, Your Honor, is going to argue that a careful searching voir dire is the best test for a change of venue. Your Honor, that case that the prosecution cites and the prosecution quotes was decided in 1976. For historical context purposes, Your Honor, Gerald Ford was the president. The internet did not exist. There were not computers. There were not cell phones that act as handheld computers at the disposal of every resident in this community. The Supreme Court of the United States, Your Honor, decided skilling in the year of 2010, when the internet did exist, when social media was booming, when desktop computers were readily available to family households, when laptops were in existence, and when every person has a cell phone. The Supreme Court in skilling in 2010, Your Honor, held that there are cases where presumed prejudice exists. This case, the skilling case, was a lot more recent, Your Honor, than 1976. We submit, Your Honor, that this case is one of those cases and ask that the court grant our motion for change of venue under the doctrine of presumed prejudice as delineated by the Supreme Court of the United States in United States v. Skilling and its progeny. Thank you.
Thank you, Ms. Stevens. Ms. Canepa, when you're ready.
Thank you, Your Honor. Your Honor, I know the court has read all of the cases that both the defense and the state cited, and along with the motion, so I appreciate that. I'd just like to address, first of all, the skilling case. As Ms. Stevens indicated, that was decided in 2010, and I think the court can rightly rely on it. The Skilling case, as this court knows, was the Enron case, very highly publicized, and yet the court in that case found that there was no presumption of prejudice, and that change of venue was not warranted in that case, given all of the safeguards that the court engaged in order to mitigate any of those concerns. I would like to point out as well that in Schilling case, the co-defendant pled guilty, well, a week before the trial was set, and the defense renewed its motion to have the case continue, or not continue, the change of venue, but the court's remedy at that point was to merely continue the case for 2 weeks. So there was a 3-week difference between co-defendant pleading guilty and the start of the defendant's trial in Skilling. And the court, the United States Supreme Court, found that that did not have a presumption of prejudice, and nor was a change of venue warranted. Just for a matter of perspective, Your Honor, in our case, the co-defendants in this case pled guilty in April of 2021 and August of 2021. That will, with the expected court date, trial date of May of 2024, will be 3 years after the plea, not 3 weeks. Additionally, with a trial date of May of 2024, that would be nearly 2 years after the co-defendant's trial in this case. So again, I think that is extremely important. Not only that, Your Honor, it will be 6 years from the time of the defendant's arrest. They cite some things about, the governor and the sheriff at that time making comments at a press conference. That will have been almost 6 years prior to the start of this case. And it will be more than 8 years since the Roden family was found murdered in their homes. So, as far as the distance between these events, the passage of time, I would like to note as well, and one of the cases that I cited was the Mamone case, and one of the factors that the court looked at is publicity that was generated by the defendant himself. He was hard put to complain about, right? You can't generate publicity and then stand up here and complain about it and suggest that that requires a change of venue. I would note that unlike most defense attorneys in this case, any of the other defense attorneys in this case, these defense attorneys representing Mr. Wagner, Billy Wagner, routinely talked to the press. In fact, last time we were here, they walked out front of the steps and gave a little sound bites to the press. So again, perpetuating the media coverage of this, I can assure you the media doesn't have as good of, if they don't have a good sound bite, it's unlikely that it gets on the news because, they're in the business of selling papers and selling the news. So I would just ask the court to consider that. I think that it's hard put to say that the media coverage is not lessening, and then take steps upon yourself to make sure that it doesn't lessen. Speaking of the size of the county, we actually had 333 people respond to the summons out of the 1,000. So basically a third of those summoned. Clearly, we can summons more if that's a concern. However, I would note for the record that that's only 5% of registered voters. 1,000 is only 5% of the registered voters that we summoned. 2% of registered voters showed up, and we only went through half of those in order to get a jury seated in this case. And I would note for the record that we had to death qualify those individuals as well. So if there is no death qualification in this case, which remains to be seen, that also takes off that concern. I would also like to note, just for the court's edification, because I did not know this until I went through the trial in Georgia's case, but the registered voters is not the only source for the jury pool. I know that's true in Franklin County, where we've all practiced, but in Pike County, it's not just the registered voters. So there's 17,500 registered voters from which to draw for a jury pool, but they also go with the Bureau of Motor Vehicle Registrations as well to poll their jurors. So again, there's more than the 17,500 potential jurors, but we only went through 1% of them, Your Honor. We have 99% of 17,500 registered voters, plus whatever else the number is of the registrants at the Bureau of Motor Vehicles, that remain untouched in this case. And I would like to note that there were some comments made in the motion that simply were not factually true. It was not true that most of the jurors had some connection with the Roden family. That was not true at all. Again, we were able to seat a jury. We did a very careful and searching voir dire. We had a long-form jury questionnaire that addressed not just the death penalty, but also their knowledge of the victims or the defendant's family or any of the law enforcement or other people, local, witnesses, etc. And we were able to, and I assure you that Judge Durian is a very careful and cautious judge, and I would note for the record as well, the state is not interested in building error into this case, right? So obviously, we're not going to advocate for something that we think is obviously prejudicial in this case. So as far as the size, again, Your Honor, we only tapped 1% of the registered voters in order to seat a jury of 12 with 6 alternates. So that was 18 people that passed all those hurdles, all those challenges for cause, all those peremptory challenges. Additionally, Your Honor, there is no news outlet in Pike County. The news outlets that you see here are not local news. These are Cincinnati and other, larger news outlets. So, Pike County itself is not immersed in that. I would also like to point out that while George's trial was certainly streamed live, 2 important factors on that. Jake's testimony was not televised, audio or video. Neither was Angela Wagner's testimony. Neither one of those individuals' testimony was televised via audio or video. I think that is very important. There is nothing, and also I would say, very much like Skilling, the court held that while there was lots of news coverage about the collapse of Enron and all their misdeeds, right? Lots of coverage of the events. There was not anything covering the singling out of the defendant himself involvement, specific involvement in that case. And I would say that is exactly what's happened here, Your Honor. Jake pleading guilty is Jake admitting his culpability. Angela pleading guilty is Angela, admitting her culpability. George being found guilty, it was simply the jury's determination that George was guilty of the crimes that they found him guilty of. There was nothing in George's trial that focused on Billy's guilt. Now, again, there might have been some, tangent testimony that included Billy, certainly, but I would suggest that the most critical testimony in that regard came from Jake and Angela, and again, though their information was not televised. The comment, I guess what the concerns are, because prejudicial information is information that gets into the media that is not going to make it into this courtroom. The fact that Jake pled guilty is going to come into evidence. Probably in my opening statements, I realize that's not evidence, but this is not something that's going to be hidden from the court or from any prospective jury in this case. The fact that Angela pled guilty, also. Jake and Angela both appeared and testified against George. We have no reason to believe those individuals will not appear and testify against this defendant as well. So again, anything that any prospective juror has heard is not anything that they are not going to hear lawfully, in this court. However, again, the court can take steps, and undoubtedly would take steps to mitigate that and get assurances from the jury that they can decide this case based solely on the evidence that comes in against this defendant, right? None of the stuff against the other defendants is relevant unless the same evidence is introduced in this case against this defendant. The only thing that I heard her say is that Sheriff Al Lewis, who, by the way, was never a sheriff, he was a major at the Pike County Sheriff's Office, left and went to Ross County, but at the time he made those comments was not even law enforcement anymore. He's now retired. And I would suggest, the comment that there's one more left and we're going to get him, or whatever that comment was, an indictment itself puts the world on notice that we think this individual is responsible for the crimes, and certainly as the people bringing the charges, we intend to prosecute the case, in this case. So, and I know that they did not hit on, the juror's conduct being inconsistent with the presumption of prejudice, which is the fourth factor in Skilling, which, by the way, the court said that these were not the only factors to be considered. These were just some of the factors that they looked at. But certainly, again, the court can take steps to mitigate the concerns in this case. And when the same concerns existed for George Wagner. In fact, in his trial, the pleas of guilt by Jake and Angela, his brother and mother, were much closer in proximity in time to that case. But Judge Aderian held that we had to at least make an attempt to seat a jury. And again, we did a lengthy jury questionnaire. We did individual voir dire. I might add that unlike in Skilling, where the defendant complained that it was only a 5-hour voir dire, that was too short, we did 12 days of individual voir dire, and that was after 8 days of bringing everybody in and having them fill out the questionnaire and excusing people for cause, sickness or work and those sorts of things. So again, I think there are steps. I certainly would the state would not oppose if the court wanted to close pretrials from between now and the actual trial, or rule that we can't, neither side can talk to the media going forward. So again, there are things that can be done. This does not
Do you want to hold up just a moment?
Sure.
And there's some kind of a nationwide alert, and I guess we're there. That it? Okay.
Okay. So I guess the bottom line is, in their motion, they say that there is a presumption of prejudice if they can demonstrate that any attempt to see the jury in this case would be in vain. And I think that is a very hard thing to say, knowing that we were able to do that exact thing in the co-defendant's case, in this case. So again, and like I said, only exhausted 1% of the potential registered voter portion of the jury pool. So I'm sure it's much less when you consider that. Clearly, Your Honor, there is no crystal ball, for any of us, for the court, for the state, for the defense to say whether or not we will ultimately be able to seat a jury. Having been through this in this county, I feel confident that we can, but that's not anything that this court, is going to rely on. We can speculate, but this is why the Ohio Supreme Court has said that the best approach is to attempt to seat the jury for all those reasons. And I guess, I cited this in my motion, but again, this was cited by Skilling in 2010, so I can appreciate that, I'm being accused of relying on old case law, although I did cite the Chauvin case, which is, the George Floyd case,
Sure.
which certainly was very high publicity. But Skilling references some of these quotes, that prospective jurors cannot be presumed partial solely on the grounds of exposure to pretrial publicity. A fair trial does not mean jurors must be totally ignorant of the facts and issues involved in an important criminal case that has generated public interest, and scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of this case. The United States Supreme Court has aptly described this as prominence does not necessarily produce prejudice, and jury impartiality does not require ignorance. So I don't expect these jurors to come in here and say they've never seen or thought or heard or talked about this, or even have an opinion. As this court knows, I know, you've been through many more trials, probably than both of us combined, possibly. The bottom line is, can the juror set aside any of those preformed opinions, anything that they've heard outside of the courtroom, and decide the case based solely on the facts that are introduced into evidence in this defendant's case? I guess some of the reasons why, courts are asked to first attempt to seat a jury in the locale. We had many witnesses that it was very hard for them, civilian witnesses, that it was hard for them to make it to, court, even being, as close proximity as this. The victim's family, as you see sitting here, there's always a number of them here, at least 5 to 10 on any given pre-trial, and I assure you there was more than that during the trial. The hardship that would create to them, and again, I think that's a fair consideration for the court. You're not limited to just what Skilling itself says. You're not limited to just those factors. So again, Your Honor, the state would respectfully request that the court overrule this motion for a change of venue at this time. I don't disagree that the defense should be allowed to renew this motion if, once we get started seating a jury, that it becomes clear to the judge, or the court becomes convinced that a fair and impartial juror can't be seated. Certainly, I would expect them to renew a motion at that time. But at this point, Your Honor, I would ask the court to find that there is not a presumption of prejudice in this case. They simply don't meet that standard, and to overrule this motion without prejudice such that they can renew the motion at the appropriate time. Thank you, Your Honor.
Thank you, Ms. Canepa. Ms. Stevens.
Thank you, Your Honor. Just briefly. May it please the court. Your Honor, Ms. Canepa just explained to you and wanted to discuss with you the passage of time since the indictment, since the trials. However, it's not just passage of time that you look at, Your Honor. That is not the factor delineated by the Supreme Court of the United States. Rather, the factor delineated by the Supreme Court of the United States is with respect to media coverage. Whether or not the passage of time has lessened the media coverage. It has not here, Your Honor. Regarding the second factor, the size of the community judge, Ms. Canepa wants to compare and contrast Pike County with the county in which the Enron case was tried. Two way opposites, Your Honor. Pike County is small compared to the county that the Enron case was, the Skilling case was tried in. Thirdly, Your Honor, Ms. Canepa wants to state that, incite the media asking us procedural questions at the last hearing date when talking about the pervasive media coverage. And she wants to equate that, Your Honor, with the government somehow calling our client an evil monster. The procedural aspects of us answering the media questions do not rise to the level of any type of prejudice. And that's what the difference here, Your Honor, is. And that difference being the prejudicial media statements that the state and its officials and the government has in fact perpetuated throughout the entirety of the case. Your Honor, concerning the untruthful facts that Ms. Canepa did in fact address, in the motion, in the defense motion, it is written that it was reported that almost all of the potential jurors had a connection with the Roden family. It was reported, and I cited to those media reports that did in fact report that. I am not saying, Your Honor, that I was present for jury selection and that we in fact heard each and every person say that, oh, they had a connection to the Roden family. That is not what the defense is contending. The defense is merely contending what the media reported. And it was in fact reported that almost all of the potential jurors did in fact know something. It is cited in my motion with the appropriate citation, Your Honor. With respect to whether or not Jake and Angela's testimony was televised, Your Honor, perhaps that it wasn't televised, Jake or Angela's testimony. However, reporters were still in the courtroom. Jake's testimony was still reported on. Angela's testimony was still reported on. Those news broadcasts were televised all over this county with respect to what Jake said, with respect to what Angela said. And so while their testimony wasn't streamed, their testimony still got to the residents of Pike County, Your Honor. Ms. Canepa told you that the same concerns existed for George Wagner in the first trial, Your Honor. However, the same concerns don't exist, Your Honor. We've already had a trial here in Pike County. At the last trial, there was no trial before my client's son was tried. And so the concerns are vehemently opposed, diametrically opposed. Here we've had a trial in this county. And so because we've had a trial in this county and because that trial was in fact decided upon, those concerns are diametrically opposed, Your Honor. I believe, Your Honor, that's, again, we're asking that that the court grant our motion for change of venue based on the doctrine of presumed prejudice.
And Your Honor, if I may?
Yes, sir.
Just on a side note, the gag order was put in place by Judge Deering because a couple things happened early in this case that had nothing to do with our group. I specifically got clearance from Judge Deering that we were allowed to comment on procedural aspects of the case or legal concepts. Every single time I've been asked about a fact of the case or a theory of the case, we have declined comment and relied upon the gag order to do that. So I think it's disrespectful, and I think it's a disservice to the media and what they do not to answer a procedural question. So when Ms. Canepa says we were on the front steps of the thing last time we were here answering questions, yes, I was, Your Honor. I was answering procedurally why it didn't go forward and what was going to happen next procedurally, Your Honor. So any comments you'll ever hear from me are not sound bites, Your Honor. They're not to taint a jury pool or anything of that nature. They are simply addressing respectfully procedural aspects of the case or a legal concept.
All right, thank you. Do you have anything else?
No, Your Honor.
All right. We're finished then? All right. Well, as I said, you know, some additional issues have been raised, and I probably will reread a couple of the cases and look for some of the specifics that were mentioned here, but I will put together a written decision announcing my decision as to the defendant's motion for a change of venue, and I will do that as soon as I can reasonably do so, and I anticipate that will be fairly soon. Is there anything else, counsel, from the state,
No, Your Honor.
from the defense?
No, thank you very much, Your
Well,
Honor.
thank you all. Is there anything else you want to talk about in chambers, or are we good?
We're good?
I think we're good. I appreciate the
good,
court.
All right, thank you.
Thank you.
Yeah, that's all. Appreciate it. We'll always get here early to talk to you. Here, appreciate that.
Thank you.
And I'll see you. Take care.
Yes, AAICLY.
V or P?
PH.
Mr. Collins or Mr. Hayes?